Good morning everybody here in the United States and magandang gabi po sa mga Filipinos in the Philippines. So I'm just updating some of my social media platform and then we'll start with the topic for today. Ito na yung maraming hinihintay ng karamihan, the J1 Waiver Updates. So I will cover both the Philippine No Objection Statement as well as some guidelines and trends on the exceptional hardship at the Department of State side. So, hintay lang tayo mga 2 minutes and then I'll start with the live. And again, can you give me a feedback if I sound okay? Pakisulat na lang din sa comments section. Hello, Tony Torres. So, if you could actually state in the comment section kung saan kayo located ngayon. So, just for me to know. I thank you. So, I sound good. Okay po. Hello, Sir Rolly, Ma'am Marianne, Miss Bernardo, North Carolina. I might be visiting Arizona soon, as well as Las Vegas. So, and this is in relation to waivers and H1B. So, stay tuned. Okay, everybody. So, again, good morning here in the United States. I'm Nick Caracal. I am based here in New York. And magandang gabi po sa mga tao sa Philippines. So, I know that there are people who are not Filipinos watching this live and who are also interested to know updates on the J1 waivers. As much as possible, I would want to speak in English, but most of the time, I also would put in some Tagalog words just to put emphasis on some of the terms or topics or updates that I would want to stress on ng elaborate, no? So, but if you actually notice, StreamYard now added a feature where they actually translate what I say, so you can just take a note of that, or you can actually ask in the comment section. So I'll now start to share my screen just to be in the same page and would actually guide us as we talk about each topic of the J1 waiver updates. And I will be sharing my screen. Here you go. Hi, Sir Dennis. All right, let's start. I just want to have a reminder that this is a Facebook Live event only for the intention of educating or sharing some of the fundamentals or legal premise of the topic today. Kung may tanong man kayo and I answered that, don't take it as a personal advice from me. This Facebook Live does not create attorney lawyer-client relationship. But if you would want to discuss your case in details, you could send us a message um, during our office hours from Monday to Friday. So, since this is a J1 waiver topic, we'll talk about, and you will be hearing about INA 212E. This is the Immigration and Nationality Act, covering immigration rules and regulations in the United States. But when you hear about INA 212E, this is equivalent to the 2-year home residency requirement. So, ang ibig sabihin nun, especially for the teachers who are not in the United States and who are actually planning to come to the United States on a J1 visa, it means that after your program ends, you have to go home to your home country or the last country of residence, and you have to spend 2 years before you would be able to apply for H1B or apply for the immigrant visa or the green card application. So, paulit-ulit nating banggitin yung 212E na yan, at least alam nyo na what it meant. So, I'm gonna start with, ano bang mga basis, kasi palagi itong tinatanong, no? So again, ang normal natin ginagawa, as I actually go through the live, if you have questions, just write it down in the comment section. Then, throughout our presentation, I'll select some of the questions that I need to ask, I need to answer. and then pag-uusapan natin as a group. So everybody learns from someone's perspective or concerns. No? So I'll be covering both the Philippine EVP guidelines on the J1 waivers as well as the Department of State. So let's start with the grounds. Yung grounds, there are 5 grounds of obtaining a waiver, and isa na dito is the no objection statement, and this is the most common um, ground ng waiver na ina-apply ng mga J1 applicants, and this applies to any nationality, whether you're Filipino, Jamaican, or kung saan man. Yun yung pinaka-common na ina-apply natin. So when you apply for the no objection statement, you are not actually applying with the Department of State. You are applying with the host country. So in this case, Filipino nationalities will apply with the EVP in the Philippines and request for a waiver. Ano bang ibig sabihin ng waiver? Kasi nga, the rule requires you to go home after your J1 waiver program ends, and kung pasok ka dun sa eligibility na grounds to apply for a waiver, then a waiver means that you are asking the US government with the support of the Philippine government na hindi ka na uuwi dahil for whatever grounds or reasons or arguments na ipipresent mo. Once it's approved, then you don't have to go home to comply with the 2-year home residency requirement, and you can now, at that point, apply for H-1B or the immigrant visa or the green card application. The second one is the requests by an interested U.S. government agency, or ang tinatawag natin na IGA. So for the last few years, I've been saying in my Facebook Live that the government is no longer accepting interested government agencies, especially for the teachers. So in this case, there are 2 government agencies that might be able to apply for you. So the common one is the U.S. Department of Education, and then the second one is the Bureau of Indian Education. So ito yung mga tribal schools, and there is a good development on this regard. I actually just learned with one of the states that actually had successfully convinced the Bureau of Indian Education to support their application for a waiver. So I will not touch heavily on this, but marami kasing nagtatanong, nagre-react doon sa post ko. On the post ko sa Facebook Live, I actually said that if you are interested, if you are, number one, if your school district is part of the tribal schools, right? So then you are under the Bureau of Indian Education. So what do you do? Unlike the other types of waivers where it is an individual application, in the case of the interested government agency, it is actually your employer, in your case, the school, who will be applying for the waiver on your behalf. So in the case of the Bureau of Indian Education, then the school files that request in support of the Bureau of Indian Education, and then the Bureau of Indian Education will endorse your application with the Department of State, and then the Department of State will deny or approve that, and then it will be forwarded to USCIS for the issuance of the approval notices of the waiver. So just recently, we're talking about 1 to 2 weeks ago, one school district under the tribal education system. So then it was the Bureau of Indian Education who had successfully filed for the longest time an interested government agency waiver. So do not send me a message asking, hey, how can I do that? And so on and so forth. So ang sinabi ko nga sa post, if you are interested to open that conversation, you have to reach out to your human resource department, ask them to get the support of your respective senators and congressmen so they could actually help lobby for you in support also, or in coordination with the Bureau of Indian Education, so that they could actually prepare a convincing argument that the Department of State will support your application for the interested government agency. So for the first time, after 2 to 3 years that I've been doing Facebook Live, I've been now saying that at least it opened doors for the IJA for teachers. So again, yun lang yung guidance na ibibigay po ko as far as the IJA is concerned. The third one is the persecution. It's actually similar to the application for asylum, but It's rarely being used for teachers. So there are people who are actually sending me messages that, hey, can I apply for persecution in the grounds of race, sex, or nationality, and so on. But it really applies to Filipinos, though. But it for some nationalities it does apply, but for Filipinos, I don't think I've come across a case where the persecution applies. The fourth one is the exceptional hardship. So if you're gonna rank of all these grounds, ano yung ginagamit natin or ina-apply for the application for the waiver? It's basically the no objection statement and the exceptional hardship. And I will be talking about those grounds in more detail as we go along with this presentation. And then the fifth one is the request by a designated public health. So this basically, Conrad State 30 basically applies to physicians. But what we are actually trying to lobby with the senators and the congressman is if they could actually expand the coverage of Conrad State 30, because for now, as of now, it only covers physicians and doctors who are actually assigned in rural areas. So the beauty of that bill though, or the beauty of that law is actually saying or encouraging foreign doctors to be relocated or to be assigned in remote areas in the United States because no American doctors would want to work there. So they actually say, hey, foreign national doctors, if you want to get green card or H1B in the United States, you are willing to at least work in these areas, which is very rural. This is not the type of cities that we get used to, like Manila, Cebu, or Davao. Uh, but then, in exchange of that, you will be eligible for H1B first, and then it actually open doors for you to the green card and then the U.S. citizenship later. So, what we are lobbying now is that the senators and congressmen, and I heard that that state that sponsored the IJA for the school district under the tribal schools, are now convincing the congressman to actually open or pass a bill to modify or amend the bill on Conrad State 30 to include teachers. Because whether we like it or not, there's a big scarcity of teachers across the United States. So that's good news then, right? But for purposes of my presentation today, I'll be covering only the no objection statement as well as the exceptional hardship grounds to focus on those two grounds. So, sagutin ko lang muna yung mga tanong dito related to IJA because I don't want to repeat that afterwards. So, I have a question here. Desiree, what is the trend of IJA now? I actually just stated that for the first time, one school district has successfully convinced the Bureau of Indian Education to approve an IJA application. So I cannot reveal the details of what school district, what state it is, but what I do encourage you is to reach out to your HR so that your HR could reach out to your congressman and or senator to start the conversation of applying on your behalf the IJA waiver. So again, I just want to emphasize the IJA waiver is not an application that you will initiate. It has to be initiated by your employer, in this case by your school district on your behalf. But the negative side of the IJA waiver though is it's not for everybody. So what I'm trying to say is yung other grounds kasi no objection statement on the ground na may asawa kang US citizen or permanent green card or permanent resident, or if you actually have a US citizen child, then you submit your own application. That doesn't it's hindi ganon yung IJA. The IJA is initiated by your employer. So kung ako yung employer, ang isasali ko lang doon sa IJA are those people or my employees who actually contributed much to the growth or development of my school district. So what does that mean to you then? So ang ibig sabihin nun, for you to be able to have the chance of being applied on your behalf ng IJA mo, din pakitang gilas ka sa school district mo, right? Because that's the only way that your HR will be convinced to lodge the IJA application for you. Feb, tribal school is also a school in the reservation area. Yes, ang tawag doon tribal school districts. They are part of the Indian School Bureau of Indian Education. Okay, so let's move on. So then let's start with the exchange visitor program because this is the commonly applied ground for the waiver under the Philippines. But instead of me creating specific slides, I would rather use the actual website of the EVP. So, ano yun? Hindi ko nakikita ang slides ko, but can you actually tell me that you are seeing my slides or I will just see it here? All right, so I'm now sharing the website of the EVP Philippines, and we're gonna talk specific portions of the procedures here. So what it's actually saying is, naalala nyo, because of the pandemic, the EVP Philippines stopped accepting applications, but as of June 2021, they actually resumed accepting applications for the no objection statement. But some Filipinos confuse it with approving application. So dalawang magkaiba yun, right? Accepting your application is a totally different case from approving your application. And I understand where the confusion is coming from because before the pandemic, if you are married to a U.S. citizen or a green card holder, if you have a U.S. citizen child, then the EVP in the Philippines automatically approves your application for the no objections statement. But with the new guidelines of the EVP in the Philippines, that is no longer the case. So, kung titingnan natin dito, ito yung portion na sinasabi niya, no? Under the revised guidelines and procedures on the waiver of the two-year home residency requirement, on NOS applicants whose basis of application are among the following will no longer be issued an NOS automatically. So you could still apply, but it doesn't mean that once you launch your application, automatically i-approve yun, just like what happened before May 25, 2020. So ano ba yun ang sinasabi niya? So the applicant is married to a US citizen or legal permanent resident or has a minor child who is a U.S. citizen residing in the United States. The applicant is a religious worker. The applicant has an ailing member na pag-uuwi sila, then it actually is a life-threatening event. Or number four, the applicant is age 60 and above. So if your case fall into any of these four, you may still submit your application, but hindi na siya automatic grant or hindi na siya automatically approved. So then the EVP committee will be able to look into your case. So then pag-aralan nila if you fall into a meritorious case. So ibig sabihin, there's a special circumstance mo, then they actually would discuss kung okay, gagrant ba natin to or hindi. Now, if they actually see that there is merit in providing you the opportunity to be approved or issued a no objection statement, then o-offeran ka daw nila ng alternative arrangement. Ano bang ibig sabihin ng alternative arrangement? So, in coordination with the EVP committee, they might actually identify some projects for you to focus on kasi the rule requires that you have to have at least 20 beneficiaries. So, di ba, dapat uuwi ka sa Philippines. So, you could basically share whatever you're learning from the program to the Filipino students. But since hindi ka na uuwi, then you are going to train at least 20 beneficiary teachers kung ano yung program na pinipresent mo. And then you are, I think, required to pay 1,500 US dollars to fund the program for the training costs. Then once you comply that for 40 hours, then you will be issued the NOS. So hindi siya automatic, guys, ha. So kailangan mo munang mag-submit and then it's the EVP committee who gonna decide if your case fall into a meritorious case, then they will offer you an alternative arrangement. So then once that's completed, you will be given the no objection statement. So then balik tayo sa Facebook Live natin kung may mga tanong tayo in relation to the EVP guidelines. So magtanong na kayo ngayon about the no objection statement. So I'll just wait for some. Oscar, how about attorney in Catholic school? Is there a chance po? So The problem with the private schools, kung may waiver, the waiver in itself applies regardless kung yung employer mo is private or public. The problem with a private employer, once your waiver is approved, they cannot file the H1B for you right away. So then they need to go through lottery and so on. But if you would want to know more about the H1B process, you could basically watch other Facebook Live that I have recorded in my YouTube account. Meron po bago labas EVP item na okay na ang NOS. So again, Ira, ito yung sinasabi ko na people get confused with the new guidelines na pinalabas ng EVP. Ang sinasabi ng EVP, they now resume applications for the no objection statement. But hindi nila sinasabi na pag you are married to a US citizen or if you have a US citizen child, automatic grant. If you actually notice, especially for those who are members of the Filipino teachers in the US, I haven't heard of anyone who has been granted or approved of the NOS yet, even with the revised guidelines. So again, sinasabi nila the EVP should review your application and be able to review your case. If it's meritorious, then it will be approved. But it really depends on the EVP. So klaruhin ko lang yun ha. Iba yung inopen ng EVP na magtatanggap na sila ng NOS, iba yung automatic approval. What I'm trying to say is, anytime you can submit your application, but it doesn't mean it will automatically be approved. That's what I'm saying. Sige, marami na nagtatanong dito. So yun, Ira, no, I hope it gets clarified na okay na, when you say okay na, it actually means okay na mag-submit, okay na mag-apply. Klaruhin lang natin yung ano kasi nga yun yung sinishare ko nga na it's the website of the EVP just for clarification. Kasi sometimes yung mga links din sa internet confusing din eh. So that's why I showed the EVP website. Marilyn, how long does it take for them to process an NOS? Also, can I apply on us and hardship waiver at the same time? So let's take this question one at a time. No, how long does it take for them to process NOS? Based on my experience when I was accepting NOS in the past, 1 to 3 months. 1 to 3 months, they already get a decision on that application. So it really depends on the timing kung kailan mo sinubmit yung NOS mo, availability ng officer or the person who will be assigned to review your application at kung when it will be scheduled by the committee to review your application. But in my experience, 1 to 3 months, they normally give you a decision. So, but alam natin na nagka-pandemic, there's a lot of backlog at the EVP. So again, I don't know how they are being structured. That also affects their ability to make decisions on the applications. Second application, can I apply NOS and hardship waiver at the same time? Yes. There is no restriction as to applying for both grounds. Ang careful ka lang kasi pag kunwari nag-apply ka ng NOS at na-deny yun, you cannot apply again unless you have other grounds that you could actually raise in your application. So exceptional hardship is applied through the U.S. Department of State. The no objection statement is applied through the local host country, in this case for the Philippines. CJ, how if my U.S. citizen husband is 69 years old? He can come with me as okay. So maraming grounds yung exceptional hardship, right? And I'll talk about that in a specific slides. I will not go to the detail, but it somehow give you an idea what arguments, factors you could basically use. Jerry, are there any information quarterly regarding the change of visas in the United States, like a bill or act that supports us to change the U.S. visa? So I presume you're pertaining to the J1, no? So, but then again, when you apply for the J1 visa waiver, you were informed that after 5 years, you need to go home to the host country to basically spend your 2 years, no? That's the 2-year home residency. Yun yung ibig sabihin ng 2-year home residency requirement. Now, the question is, meron bang bill to change that? I don't think there is a bill to change that, because changing that rule basically destroys the purpose of the J1 waiver in the first place. What they are actually saying is they are expanding, or they plan to expand the grounds of the waiver. So, kagaya ng sinabi ko kanina, Conrad State 30 applies for physicians who are actually assigned in remote areas in the United States. They would want to expand that to cover teachers, no? So there are rumors that there are some congressmen, senators who are trying to apply or pass a bill, but as of the moment, I am not aware of any specific state that has actually launched the amendment. I hope I answered the question. Joy, when is the best time to apply for NOS? So, under the current rules and regulations, it may be very difficult to get an approval. So, again, there are two issues here. When is the best time to apply? You can apply anytime. But if you look into the current regulations of the EVP, so again, ibalik ko lang yung slide ng EVP. This is not my slide. This is the website of the EVP Philippines. Klaruhin ko lang dito, ha. Last sentence dito, no? NOS applicants whose basis of applications are among the following will no longer be issued an NOS automatically. This is the revised guidelines of the EVP Philippines. Now, when is the best time to apply? You can apply now. What is your chance of approval? It depends on, in your case, kung meritorious yung case mo. So, ang sinasabi dito, pag nagpo-fall yung case mo under any of the four, they will accept your application, but it doesn't mean automatically approve. So, kagaya na sinabi natin na, you are married to a US citizen or a green card holder, or kung mayroon kang anak na US citizen, or if the applicant is a religious worker, so pumasok siyang priest, non-missionary, then pwede kang mag-apply, but it doesn't mean automatically approve. If you have an ailing family member, or if you are age 60 or above. I really hope that that clarifies that question, kasi I've received a lot of messages clarifying this. So I hope that clears that scenario. Okay, moving on. Ryan, what kind of meritorious cases is EVP pertaining to, because there are no details in the guidelines? Correct, and I agree, no? Ang sinabi niya, balik tayo dito sa live again, the EVP committee will study, ito yung portion na to, will study your application and they will decide if your case merits consideration. No? Ito yun, no? Hence, only those applications whose cases may fall under highly meritorious circumstance, such as, but not limited to, applications from researchers or professionals whose continued stay in the United States will advance the Philippines' national interest, will be granted. So, example, now, if you're leading a project in your school district that basically, sa tingin ng EVP committee, if you will be able to share that to the Philippine government, will actually improve the way of teaching or methodology in the Philippines, then the Department of Education, sila kasi yung mag-a-assist nun eh. So, yun sinasabi niya na in its deliberations of NOS applications, the EVP committee will consult concerned government agencies or private institutions. So, since this application is focused on the teachers, it will be the Department of Education who will review and assess your proposal kung ang proposal mo merits a second consideration na ma-approve ka, no? Kasi then again, ano bang purpose nga nung project or alternative arrangement mo? Magsasubmit ka ng proposal mo together with your application. Ngayon, pag nakita nila na meritorious yung proposal mo, then they will submit it. Isa-submit mo through the EVP, okay? And then yung EVP will actually assign it to the Department of Education for them to seriously look into the proposal, and then sila yung mag-assess. Sila din yung mag-recommend kung meritorious yung case mo. So to answer your question, Ryan, I agree with you. There is no specifics provided in the guidelines. So what does that mean to you then? So kung sa tingin mo meron kang significant project na in your own assessment would actually help the Philippine government, just submit it anyway. No? Kasi pag kunwari binasa ng EVP committee at they need more information, they will let you know that, hey, can you submit more documentation or more information for us to better understand your proposal? So again, we talk about this in the past. Walang specific format yung proposal. So just make a proposal to the EVP regardless of formatting or contents. Ang importante lang doon is kung sino yung nagbasa ng proposal mo, naintindihan kung ano yung pinopropose mo. Now, if they need more documentation or information, they will let you know. Okay? Rondel, good day. Alam ko po na uwi ako sa Pinas para ma-render ang 212E ko. Pwede po kayang magsabi sa aking admin ang option na EB3 para magalaw na ang aking application. So, Rondel, I don't know if you're on the third year or in the fifth year, but what we normally do sa mga school districts na clients namin, once they are now being educated as to the J1 visa and the H1B options or the immigrant visa options. If you are already on your fourth year, we actually convince the school districts to start their green card application. Normally, we call it the labor certification process kasi yung labor certification na yon could actually take up to 2 years at least to complete that process, enough for you na makomplete mo yung 2-year home residency requirement. By that time, meron ka ng interview sa embassy. So to answer your question, pwede kayang magsabi sa aking admin, yes, you could basically start a conversation with your HR na you are interested to start your green card application habang nandito kayo. And then it is very advantageous pag nandito ka, para kung may concern ka, you could talk to your HR while your green card process is ongoing. Devon, can you repeat an example of meritorious circumstance? So again, walang klarong guidelines, right? So even the EVP did not give us specific examples of what are meritorious case. But for the teachers, so halimbawa, meron kang na-develop because even teachers are creative in actually teaching the students, no? And then, kung sa tingin mo na-improve yung performance ng school because of the methodology na in-apply mo in your way of teaching, you could basically make that proposal in writing to the EVP na, hey, you know what? I actually adopted a new methodology that improved the performance of the students. Sa tingin mo, makaka-improve yun pag binalik natin or in-adapt natin sa Philippine school system, then focus on that, then let the EVP decide if it's meritorious or not. So that's basically an example I could actually provide. When is the best time to apply for NOS during the fourth or the fifth year? So ito, may mga teachers pa rin tayo nagpo-fall into the excitement of filing the no objection statement simply because they are married to a US citizen or a green card holder or nagkaroon sila ng anak. So what we've been actually saying in the past is once you apply for a waiver on your second year or third year, they will deny your 2-year extension. So what we are saying then is, to answer your question, Aaron, the best time to apply for the waiver is on your fourth year or fifth year. Kasi approve na yung extension mo. If you're going to apply it on in your second year or third year, kung na-approve, okay lang. Kasi you can apply for the H. But what if it will be denied? Then you can no longer work or hindi ka na ma-approve dun sa 2-year the 2-year extension mo, no? Because how it works is, once you apply for the waiver, una, tinatanong kayo ng J1 sponsor mo if you applied for a waiver. And then you cannot lie at that point. Pag nalaman nila nag-apply ka ng waiver, then they will not extend you. That's one thing for sure. But even in instances where the J1 sponsor did not ask that question, once the waiver is approved, the Department of State will notify your J1 sponsor that you applied for the waiver and the waiver was approved. And your J1 visa will be canceled at that point. So, to answer your question, the best time is when your extension is already approved. Saka ka mag-apply ng waiver. Whether NOS yan or exceptional hardship. Jude's Meal. Good evening po. I'm here already in the Philippines. Can I apply for NOS here? Kung titingnan mong maigi yung guidelines nila, uh, especially if you have a US citizen child, you should apply for a waiver for children who are residing in the United States. Yun yung guidelines. So you can review again, you can visit the EVP website and clarify that because it's very clear. I mean, you could actually read there kasi nga very clear naman yung guidelines nila. So to answer your question, Judes, me, I don't think so, right? But ibang usapan yung you started the application while you are in the United States. Iba yung sinasabi natin, nakauwi na kami, makakapag-apply ba ako? No? I don't think so. No? In that case, you might try the exceptional hardship route if you are already in the Philippines. Rochelle, what if chartered school? Now, chartered school is an interesting type of school, right? Kasi for the understanding of our audience today, when you say chartered school, it is a semi-private slash public school. So yung school na yon is being supported by a bill because they were in a nature of a private school, but they are actually getting funding from the public government because there are areas in the United States na walang school district na create ang public school system, but then here are private entities who actually put up their school investment. I mean, putting up a school, and then they need funding from the government. So it really depends on the wordings of the bill that created the school, but most chartered schools are eligible for H-1B cap exemption. So to be sure, you could basically talk to your HR, and then your HR will talk to an immigration attorney, and then the immigration attorney will be able to give guidance to the school if whether or not they would potentially qualify for H-1B cap exemption or not. Rosal, if I will apply for a J1 visa and my child will petition me because she is a US citizen and will turn 21 next year, can I stay in the United States? So, Rosal, no? Basic principles natin, again, for the J1 waivers. You cannot apply for an H visa. You cannot apply for a tourist visa or a student visa. You cannot apply for a green card unless you have a waiver approved. While I am happy for you na meron kang ibang ground for the application ng green card mo because your US citizen child will turn 21 next year, if you are subject to 2212E, then you still have to go home and render your 2-year home residency requirement. Is there a waiver for a US citizen child to petition a parent? Unfortunately, no. The waiver only covers immediate relatives. That means a U.S. citizen child, a U.S. citizen spouse or green card holder spouse. Other than that, they cannot file a waiver for you. So in your case, you really have to render the 2-year home residency requirement in the Philippines or your last residence abroad. And then, if a-file ka ng anak mo, sa pag 21 na siya, then you can come back on the family-based petition. I heard you can only apply one time for NOS po. Yeah. Yes, yun yung sinabi ko kanina na be careful when you apply for the no objection statement. May tanong kasi kanina na when is the best time to apply for the NOS. So, again, you can apply anytime. The problem is if you get denied, you cannot apply again using the same ground. Okay? I mean, attorney, can I apply NOS? It depends no, kung may ground ka. So, ang ground nga nung sa EVP guidelines na yon, if you are married to a US citizen or a green card holder or you have a US citizen spouse, if you are a missionary, if you are age 60 or older, or if you have an ailing relative whose life will be endangered if you go back to the Philippines. Ma'am Little Girl, right? I think I've explained this. What about IGA? Sinabi ko na kanina, yung IGA is not a personal application. What you need to do is you need to talk to your HR. So your HR will contact your senator and congressman to help them to get support so they could actually convince the Bureau of Education. And then only then your school can have that conversation, because hindi siya individual application eh. It's the employer who will apply for you. Now the exceptional hardship waiver applies for pag-usapan natin mamaya kasi nga may slide tayo na exceptional hardship. Judy, good evening po. I am here already in Pinas po. Can I apply for NOS? Kung ang ground mo is child, no, the child has to reside in the United States. But kung kunwari, ang ground mo is spouse, I don't, based on my experience, I think you have a better chance of approval if you're gonna apply for exceptional hardship. But to answer your question, can you apply for NOS? Depends on your situation. Kung anak ang basihan mo, I don't think so. Ira, last question actually, can I still apply for a J1 visa after 2-year rule, even if I get married to American citizen? If the question is, can I apply? Yes. Is it practical? No. Kung may asawa ka ng American citizen, ma'am, I would recommend that you will apply based on the family base. Because una, mabilis yon. Pangalawa, kung employment-based kasi, so there are instances where magkahiwalay yung asawa sa American citizen because of work assignments, no? So let's just say that the spouse, the U.S. citizen spouse, lives in Vegas, in Las Vegas, right? But for whatever reason, yung asawa niya nagtatrabaho sa Virgin Islands, right? But the J1 teachers cannot just leave their work because they have their contracts and their obligations, and then when they apply for a waiver, china-challenge ng government yun eh, na hey, why are you saying that there is exceptional hardship when in fact you are not living together? So to answer your question, can I apply for another J1 visa after the 2 years? Yes, but is it practical? Does it make sense? No. I highly discourage you applying for a J1 visa waiver again, kasi mas marami ka ng option after that eh. So in your case, tell you are married to a US citizen, apply for the green card through marriage. Mas mabilis. Once you come here, wala kang restriction that you have to be working outside the place of your husband, because you don't need an employer for your green card. You will get your green card from your spouse. So ang recommendation ko, if you need guidance on that, it's on the family-based petition. You can send us a message and we will guide you on what's the best option for you. Ellen, attorney, I'm on my 5th year already and I am considering to apply for another country next year. My question is, can I apply for a J1 visa waiver on exceptional grounds while in another country, or will there be lesser chance of approval in that case? I-hold mo yung application na yung question natin na yan kasi meron ako specific slide. But I just want to touch base on you want to apply to another country. Kasi yung 2-year home residency requirement mo, it actually specifies that you have to render the 2 years from your home country of residence or for the last residence where nakuha mo yung J1 mo. I'll give you an example, no? So if you obtain your J1 visa in the Philippines, then after your J1 program ends, you have to go back to the Philippines and render your 2 years. But there are teachers who obtained their J1 while they were teaching in Thailand or in Indonesia. Then when the J1 program ends, they have two options of either completing the 2-year home residency back in the Philippines, or they can go back to Thailand and stay there for 2 years. So if you obtain your J1 visa in the Philippines, you cannot go to Canada or Thailand to render the 2-year home residency requirement. You have to complete that in the Philippines. So I hope that clarifies. Now, the second question mo na, my question is, can I apply J1 visa in exceptional hardship grounds? Let's see mamaya na kung pagdating natin sa exceptional hardship topic. A friend of mine who is a J1 teacher filed for a self-petition. She filed for all the required forms, including the I-140, adjustment of status. Lucky she got AED approved while waiting for the adjustment of status. This teacher is subject to it. She has no waiver. Will that affect the approval of the adjustment of status? Is it possible to continue to work in the US without a legal status as long as merong AED? Okay. Um, I'm not so sure when you actually self-petition. And if we pertains to a teacher, the only visa that I can think of is that person is filing a national interest waiver, I presume, or are they applying for extraordinary ability, O1 visa? So let's just assume in that. Kung self-petition kasi, and then sinabay niya ang adjustment of status, the other scenario could be a VAWA, but whether it's a VAWA, exceptional hardship, or national interest waiver, yung visa na yon can be approved regardless of the waiver. Kung may waiver ba siya o hindi. But I have to step back a little bit para klaro lang yung conversation na to na. Nag-national interest waiver ka, nag-exceptional hardship waiver ka, o nag-VAWA ka. Ma-apply to, but applying for the VAWA does not allow you to work. Applying for O1 will allow you to work. So basically, you could extend your stay in the United States, but there are limitations yung extraordinary ability and even the national interest waiver. So, pag na-approve yung dalawa, you have to apply for the green card, the work permit, and the travel permit. So, pag nag-apply ka ng green card together with the work permit, as a matter of procedure, maa-approve talaga yung work permit mo after 3 months or 5 months. The recent trends na nakikita namin ngayon, mabilis lang yun ang work permit, 2 to 3 months, approved na siya. So this is good news. To answer the question, can they continue to work in the US without a legal status? Una, once they have approved working permit, they can work anywhere, they can work any type of jobs because the work permit has no restriction. Are they still in legal status? Depends. Kung na expire na yung J1 visa nila, then they no longer has a status kasi nga expired na yung J1 visa. But are they considered TNT? No, because the filing of the green card application stops incurring unlawful presence. So, it becomes technical ngayon, no? So, just to simplify your question, ma'am, ang masasabi ko lang doon is, yes, it does affect the green card approval. Kasi kung kunwari, during the interview niya, wala siyang maipakitang waiver approval, din hindi ma-approve yung green card. But can they work legally kasi meron silang approved work permit? Yes, they can. Magkakaproblema lang sila pagdating ng green card interview. And if the green card is denied, automatically denied din yung work permit niya. So even if the work permit says it's still valid in 2023, if the green card application will be denied in 2022, then the work permit will be canceled or revoked. I hope that answered your question. So let us say I got denied in the NOS waiver due to the US citizen child, and the VP changed again the guidelines that they can waive it automatically. Can I still appeal even if they denied me already? So I'm not so sure how the EVP works, but in the context of the US immigration rules. So let's say you filed an immigration benefit and then you get denied, and then the rules and the procedures prevent you from reapplying a motion or filing an appeal, but then rules change that is beneficial for you. In the United States, it's allow you to file a motion to reopen that application and then arguing that there are new rules that's favorable to you. So I really hope that the Philippine government or the EVP in particular adopts that approach. So to answer your question, ma'am, at least try, right? Wala namang mawawala sa iyo kung mag-try ka, no? So, as of now, again, I use the EVP website. It seems to be the same guidelines that they have issued. Nagbago lang na, okay, we are now going to consider meritorious cases, we will apply alternative arrangement, but even with that, wala pa rin clarity or specificity yung guidelines na yun. So, I hope that I answered that question, ma'am. When is the best time to apply for a J1 waiver? Is it 1 year? I answered that. Apply when your extension is already been approved. Johan, which is one is better option? NOS or exceptional hardship if married to a US citizen but no child? It depends, no? Kasi, una, you can apply both. The NOS is a lot faster procedure than the exceptional hardship. Mas magastos nga lang sa'yo. Okay? So, yung exceptional hardship, reserve lang muna natin pagdating natin sa slide na yun. Does the green card application at expense of the employer or the employee? Very good question, right? So the employer is interested to filing your work visa. So in this context, they are supposed to be paying the H-1B related expenses. But the employer has no obligation to file the green card application for you. But you could always convince your employer to start the green card application on your behalf. So in that case, the employer could pay the filing fee of your I-140 because that is the form that they need to file on the employment base green card application. But they could also ask you to share the other fees because it's you who are applying for your green card application. It's your application. The I-140 application is the employer application, but the green card application is your personal application. Your employer has the option of keeping you on the H visa up to maximum 6 years. If they don't want to extend you beyond that, you need to go home for 1 year and then come back again on an H. So again, you need to understand the nature of the visa types. Now, so to answer your question, the employer may ask you to partake paying the green card application, but not the I-140. They should be paying that because that's their application. Jerick, I was able to finish the maximum of the program as J1 for 5 years, and then I go back to the Philippines, but wasn't able to finish the 280 rule and got hired as H1B holder. Am I allowed to have it or I need to comply? Okay, so klaruhin ko lang boss So 5 years ka na, but hindi mo na complete totally yung 2 years mo. So we have cases like that, but we don't schedule that particular applicant for embassy interview until na-complete niya yung 2 years because you will be denied at the embassy kung makita nila na hindi mo pa rin na-comply yung 2 years na yon. So recommendation ko, it's okay na na-file na yung H-1B mo. Generally naman yung H-1B will be valid for 3 years. But before you will set an interview date at the embassy, make sure that you already passed the 2-year home residency requirement. Else, your case will be denied. Good luck on that. Chona, yes, okay na mag-apply. Again, apply is different from being approved. What if po, if IJA ang gamiting waiver, kailan po pwede mag-apply ng waiver? So, then again, the IJA waiver is not your personal application. You need to talk to your employer, so your employer will file the IJA waiver on your behalf. J1 teacher, hey Jessica. J1 teacher here, is it possible for my J2 dependent to have his visa upgraded to EB3? So, kung ang J2 mo, ang J2 are the spouses and the children, if they are subject to the 212E, then the same restriction applies to them, no? Hindi sila pwede mag-apply ng H, hindi sila pwede mag-apply ng green card unless they have a waiver. So, nandun din sa guidelines ng EVP, the J2 visa holder cannot apply on their own. You have to apply on behalf of your children. That applies also to the exceptional hardship. So, kasi yung J2 mo kasi is dependent on the J1. So, whether you apply for the no objection statement or the exceptional hardship, it should be the J1 visa holder who will apply on their behalf. Feb, dapat po ba na under ka sa 4 na cases for filing a waiver at the same po dapat meron ka ring meritorious proposal? So, I presume you are talking about the no objection statement. So, what they are actually saying is unang eligibility mo to apply for the no objection statement is kung nagpo-fall ka doon sa 4 grounds. If you fall into that 4 grounds, mag-apply ka ng no objection statement mo. So, but kung ako ikaw, hindi naman malalaman ng EVP na may meritorious application ka pala, right? So, idagdag mo doon sa packet na yon na hey, may proposal ka. Kasi without that, they have no way of knowing na meron ka palang extra argument for meritorious cases. Kasi ganito yung mangyayari doon, right? May asawa kang US citizen, isa-submit mo yon. Based on their ground, it's really difficult to say if your case is meritorious or not. You have to submit at least an extra argument or documentation that makes your case meritorious. So, siguro pwede mong gamitin medical grounds then or kung may mga projects ka and so on and so forth, right? But kung ang consideration mo is may sakit yung asawa mo, then don't apply for the NOS, apply for the exceptional hardship. Kasi mas malaki yung chance mo doon ng approval. Rachel, I'm here in Cortez, Colorado. It's my second year now. Okay, good luck, ma'am. No. So don't apply for a waiver unless your 2-year extension is approved. May kilala po ako na nag-comply ng kanyang home residency requirements sa ibang bansa. Then bumalik po dito for H1B na po. Okay po ba yon? Or baka ma-detect po kalaunan ng USCIS? So, good question yon, no? Kasi, again, I don't know the history ng friend mo. Kasi kagaya ng sinabi ko, if nakuha nila yung J1 nila in Thailand, then they can basically go back to Thailand. Pero kung nakuha nila yung waiver nila in the Philippines, but nag-comply sila ng 2-year home residence requirement in Thailand, and then later down the road, masilip yun ng officer, later, then basically they could question the status, no? There are cases where, as of now, there are 50,000 denaturalization cases pending at USCIS. Anong ibig sabihin nun? So, may mga taong nag-apply before ng green card with their family base yon or employment base, and then kalaunan nalaman nila na it didn't apply, nag-submit sila ng falsified documents or they actually did not follow the rules, and then they apply for citizenship. At the time na nag-apply sila ng citizenship, nakita nila yung lapse na yon or non-compliance na yon, and they remove their green card status. So, I hope tuloy-tuloy na siya, but to answer your case, if masilip ng government yon, it could be a potential problem. Golda, I'm on my 5th year as J1. Can my J2 husband and children apply for any waiver for the 2-year residency? My school is willing to process. So then again, if they are subject to the 212E, they need to comply for, or they have to apply for a waiver before they can apply for the H or the immigrant visa. My DS 2019 form is not subject to 2E, but my J1 visa stamp is subject. Alin po dito ang titingnan? Would it affect pag-apply ng waiver in the future? Yes. So, the proper remedy basically is to apply for an advisory opinion. But if you're gonna do that now, chances are sasabihin niya sa'yo na you are subject to the 212E. Okay? But to answer the question, saan ba ang mas relevant in terms of applying, yung DS 2019 ba o yung subject, yung ano mo, yung visa stamp mo? It's basically the visa stamp, no? But it's arguable. Pag kunwari, sa case namin, we basically try to convince them that hey, the J1 visa stamp is wala namang subject doon, and then we rely on that because the applicant also relies on that as far as determining their status. But then again, USCIS can challenge you and encourage you to apply for an advisory opinion. Or in their own, they could basically request for an advisory opinion, and then it's up to the Department of State to say yung actual status mo. So it's not for us to say categorically na hindi ka. So in our case, we try to argue, no, bakit siya hindi subject to, kung may discrepancy yung dalawang documents na yan. Jonas, what if after my 3rd year, 1 year lang ang extension na binigay? Should I wait for my 5th year o pwede na mag-apply ng waiver? So, good question, Jonas, no? The key dito is, Kasi aware tayo na it could be extended for 1 year or it can be extended for 2 year one time. But there are also school districts who would want to extend the extension 1 year increment. So, the case at point is, pag nakita ng J1 sponsor mo na nag-apply ka na ng waiver, any request for extension will be denied. So, to answer your question, the best time for you is to apply for the waiver on your 5th year once na-approve na yung 5th year extension. uh, Little girl, no? Kagaya na sinabi ko, you can apply both NOS and IJA and or exceptional hardship at the same time. Walang restriction pag-a-apply doon kasi nga magkakaiba silang grounds. A friend of mine who is a J1 teacher filed, okay, I think I answered that question. If I have parents who are sickly, Chona, if I have parents who are sickly and need my assistance here in the US, will that be sufficient ground to apply for NOS? So, klarin natin to ha, kasi this could apply to a lot of teachers as well. If my parents are sickly and need my assistance, pasok siya dun sa number 4 ground. If you have an ailing relative, means ascendant, descendant, siblings, parents, anak, so on, whose life will be in danger pag umuwi ka. So what does that mean? Anong context nung rule na yon? So you should be living with your parents. The parents is either dependent on you financially or personally, kasi ikaw yung nagda-drive sa kanila sa ospital. Pag uuwi ka ng Philippines, wala na magda-drive sa kanila. If you are financially supporting them and your finances is coming from your earnings as a J1 visa teacher, pag uuwi ka, wala nang magpapagamot sa kanila because they cannot afford it. So yun yung context na yon. It will be very difficult for you to apply for NOS if ang situation is, my parents lives in Vegas but I'm working in California and I'm only giving them financial support. Then it may be a difficult argument. So to answer my question, and again, if yun yung situation mo, it's a really hard situation, but you really have to argue that your departure from the United States will endanger the life of your immediate relatives. Okay? But to answer the question, yes, it is a ground for no objection statement. But it's not a ground for exceptional hardship. Feb, if you get denied po sa NOS sa Pinas, it won't affect po kung mag-apply ka rin ng yes, kasi dalawang application na yun magkaiba. Feb. Charlene, J1 visa with 2-year home study requirement ending on November 28 this year. Which can I apply for a waiver? Husband is a US citizen. You're already late, no? So, again, I don't know the background of your US citizen spouse, kung ano yung circumstance niya. Questions here. Can you apply for the exceptional hardship? You should apply. But aabutan ka na magiging out of status ka or mag-expire yung J1 visa mo. You will not be able to work anymore. So then tambay ka muna, right? While waiting for your work permit to be approved if you decide to apply for the green card and work permit. Jonas, what if after my 3rd year, 1 year lang ang extension na binigay, should I wait for my 5th year? Yes. Na mag-apply ng waiver. Kasi ang fear ko, what if hindi kami bibigyan? So yun yung basically what I'm trying to say, no? Na make sure that when you, may mga school districts kasi na 2 years agad ang ina-apply. So in that context, wait for your 2-year extension to be approved before filing a waiver. But in your case, Jonas, if your school is applying 1-year increment, then hintayin mo yung 5th year mo before ka mag-apply ng waiver. Else, you will not be able to work on the 5th year. Okay, Gian, you can apply for NOS as soon as 2nd year, right? Is that 2nd year? Is that 2nd year or 2nd year in the US? Also, why should I wait until the 4th, 5th year if I'm not sure if I will be extended? Oh, good questions. Gian, no? Una, the rules in the NOS require you to apply for NOS after after you completed 2/3 of your program period. So meaning you have to finish your second year first before you will be eligible for NOS. Right? Also, why should I wait for? Hindi naman kita sinasabihan mag-wait eh. No. So, ang sinasabi ko is, if you apply for a waiver before your extension will be approved, then automatic denied na yon. Kasi nga, makikita ng J1 sponsor na nag-apply ka na ng waiver. So, it's not a question of why should I wait. It's a question of siguraduhin mong mas malaki yung chance mo na ma-approve yung extension mo if pag tiningnan ng J1 sponsor mo, wala ka pang waiver na na-apply. Kasi the moment na makita nila na nag-apply ka ng waiver, then automatically your extension will be denied. Now, as to the comment of, if I am not so sure if I will be extended, there is really slim chance of why you should not be extended if your school district or sponsor is supporting your extension. So, ano bang nakikita namin na reasons bakit hindi ini-extend yung aplikante? So, it could be a performance issue kasi yung school district, sinabihan niya yung J1 sponsor na, hey, we don't want to extend this teacher anymore because for personal reasons or performance reasons, or they were not able to comply with the J1 program requirements. So halimbawa, yung requirement nyo is to maintain yung insurance nyo, no? And then nakita ng J1 sponsor na the applicant was not able to comply with that or maintain, then that could be the reason why hindi sila ma-extend. But generally speaking, once the J1 sponsor and the employer supports the extension, it will be approved. So ngayon, ang tanong na lang is nag-apply ka ba ng waiver o hindi? Kasi kung nag-apply ka ng waiver before they approve the extension, then it will be denied. Yun lang yung sinasabi ko. No? Mary Ann, a friend of mine who is a J1 teacher filed for a SIP. Okay, I think nasagot ko na yan. Guys, kung nasagot ko na yung tanong, just refrain it from reposting again to give other questions a chance to be answered kasi hindi ko ma-answer lahat sa sobrang dami ng tanong. No? Did the EVP change the revised guidelines that they released last year regarding not automatically approval based on marriage, or is it still the same? They actually issued changing slightly the portion of the alternative arrangement. But fundamentally, it's basically the same guidelines that they issued in June 2021. No? So again, ang pinakita ko na-share ko sa screen is the actual website of the EVP. And if you actually look into that, hindi naman nagbago yung grounds no? Yung apat na yon, the same grounds pa rin doon last time. Ang binago lang doon is they will not automatically approve a waiver. Then the other portions is kinlaro nila ng konti yung alternative arrangement because in the previous versions of the guideline, walang mention about the alternative arrangement So if I remember it right, before 2020, ni-remove nila yung alternative arrangement or hindi masyadong klaro yung they are going to offer an alternative arrangement. Pero pag may asawa ka, may anak kang US citizen, automatically they will grant that. But with the revised guidelines ngayon, sinasabi nila na if pasok ka dun sa apat, tatanggapin namin, but we are going to review. So to answer your question, slightly change yung guidelines. It is fundamentally the same. They just added some points pertaining to the not automatically granted and then the alternative arrangement. Kevin, ba't nagtubuhan ng ibibang NOS para sa marriage sa US? So, then again, no, binalik para pwede na mag-apply? Yes. Automatic approval? No. Johan, so if I'm married to a US citizen po, better option po ay exceptional hardship. I'm on my 5th year J1 visa, subject to 212E, got married 2020 and started my green card application last July. Had my biometrics August, even if I don't have a waiver yet. Okay, so it's a risk, no? So kasi the rules require that you have to wait for your waiver before filing for your green card. So ano bang scenarios dito? No. So nag-apply ka ng green card mo, hindi pa approve yung waiver mo. So the possibility na mauna yung interview mo sa green card pero hindi pa na-approve yung waiver mo. So during the green card interview, hahanapan ka ng waiver approval. Now, wala kang maipapakita doon. So chances are that the officer will say at the green card interview na, oh, we cannot decide on your application until we receive the waiver approval. Then they will issue you the request for evidence. After the interview, hinahanapan kayo ng waiver approval. So that's the possible scenarios mo, no? Kay if mag-render po ng 2 years sa Philippines, need po ba magturo or may other options? No. It's not required that you teach while you are in your 2-year home residence requirement, right? It seems like it defeats the purpose of, but it's good for you though, kasi at least hindi ka nire-require na magturo if you want to go back. Ang sinasabi lang nila, you have to go back to your home country or the last country of residence. Richard, I resigned as a J1 teacher last month. I'm currently working in another country. Can I apply for Meritorious visa even if I did not comply? So again, even if you are in the United States, if you're gonna change status from J1 to something else, whether it's a tourist visa or a student visa, hinahanapan ka ng waiver, no? So in your case, dahil umalis ka ng United States, una, apply for a tourist visa is already a challenge in itself, no? Maraming factors 'yon para i-apply yung tourist visa mo. The more, pag kunwari nakita ng officer na you are subject to the 212E, and then nag-a-apply ka ng tourist visa. So I'm not saying na wag kang mag-apply. You could still apply, but your chance of approval may be slimmer kasi nga you are still subject to the 212E. What is the time frame for the USA to approve IJA waiver? So, for the longest time kasi, hindi tumatanggap ang Bureau of Indian Education at saka yung, tawag nito, Department of Education ng IJA waiver. So, to answer the question, based doon sa knowledge ko they started to apply, or the school district filed the IJA application around March. They were approved in July. So, that's 4 months. Okay? Mabilis siya kasi nga government to government and employer yung nag-a-apply, hindi yung aplikante yung teacher. Evelyn, my daughter got married to a US citizen and she is now on her 3rd year. The extension is already approved. Which would you recommend to my daughter apply? NOS or hardship? So, ma'am, una, pwede nga mag-apply ng dalawa, no? So, ang consideration mo lang doon is pera, no? If you're gonna apply now on NOS, your chance of approval maliit kasi nga hindi na siya automatically approved. Ngayon, doon sa hardship, when we accept cases kasi we don't accept cases ng exception automatically, no? Pinapa-assess muna namin ng staff ko kung mayroon ba talaga kaming ground for exceptional hardship, and we'll talk about that in the next slide. So I'll answer maybe 3 more questions, then we'll proceed with the exceptional hardship na kasi nasa exceptional hardship na yung mga questions. If ever I will have an approved working visa in Canada, can I move to Canada even if I only finish the 1st year of my J1 visa? Can you move to Canada? Yes. But kung may plano ka ulit na babalik sa US, no. Until you go back to the Philippines and complete the 1 year remaining doon sa 2-year home residence requirement mo. Johan, so if I married a US citizen po, better option po exceptional hardship. On my 5th year J1 visa, subject to want to get married and started again, you can apply both. What is your chance of being approved exceptional hardship? Depends on a lot of factors, right? Last na to, and then we'll talk about the other slides. Good morning, attorney. Our district has informed us to start getting visa waivers so they can process our H1B. Can a US-born child, we have a US citizen child, what's the best option to get a waiver approved? So, dalawang option mo, no? The no objection statement and the exceptional hardship waiver. But choosing between filing an exceptional hardship based on a US citizen child or a US citizen spouse, ang hirap makakuha ng waiver approval sa child. Okay, let's now continue with my slides here. Exceptional hardship waivers through the US Department of State. So, ano bang pwede mo magagamit na ground? So, it can be applied if you have qualifying relatives. So, ano bang qualifying relatives? You are married to a US citizen or a permanent green card or permanent resident or green card holder, or may anak kang US citizen or both, no? So, nakakatulong ba na may asawa na akong US citizen, may anak pa akong US citizen. So in our case, yeah, we added that argument na hindi lang asawa ko ang mahihirapan din yung anak kong US citizen. But hindi naman required na mayroon kang anak at mayroon kang asawa. Any of those can be used as a ground to apply for exceptional hardship. Okay? So, I hope walang tanong mamaya, wala akong anak sir wala akong asawa. Can I apply for exceptional hardship? No. So, these are the only grounds to apply for exceptional hardship. So, may parent akong US citizen. Can I apply for exceptional hardship? No. Because there is no waiver application between a child to a parent. No? So, yun lang yung klaruhin natin. Exceptional hardship factors, family ties. So, yung mga nagtatanong kanina about, hey, what is best for me, NOS or exceptional hardship? And the answer is, it really depends kung meron kang grounds, no? So, ano bang ginagamit namin when we actually file the exceptional hardship application? First consideration mo, family ties. So, family ties ba? Pag kunwari ba, oo, sasama sa iyo yung US citizen spouse mo sa Philippines, may kaibigan ba siya doon, may pamilya ba siya doon, marunong ba siyang magsalita ng Tagalog? If the answer is no, then you have exceptional hardship, no? So yung mga family ties, no? Nakadepende ba ang kanilang parents? May anak ba sila na financially dependent on them? Yun, it would help you in the family ties. So physical and or medical concerns. So halimbawa, may sakit yung asawa mo, then it can be a very good argument na pag uuwi siya sa Philippines, there will be exceptional hardship. Kasi una, yung sakit niya hindi available in the Philippines. Or kung available man in the Philippines, the cost of treatment is sobrang mahal at hindi mo afford yun, baka ma-endanger yung life niya. So then it will help in your argument. Economic ties. So in America, kahit hindi ka college graduate, you could still land a very good job and you still pay a reasonable amount of money, no? Pero in the Philippines, it's very hard to apply or to find gainful employment, especially if you don't have a college degree. So if your US citizen spouse will go with you, then it will be exceptionally hard for them to apply for a job. And if you don't have a job, then you don't have money, then it will be economically exceptionally hard. Safety and security concerns. So ginagamit namin to sa argument, but we are always being challenged as to, okay, kung American siya and if you leave, pumunta sa Philippines, does that mean automatically in danger siya? So again, marami ding factors yun, right? So depende kung saan siya mag-relocate in the Philippines. So if you are relocating in areas where there is a high level of insurgency or high crimes, personal crimes, especially kidnapping for ransom, or burglary, then it really yung endangers their safety and security concerns, right? But if your location, yung crime index niya medyo mababa, then you may not be able to use that argument. Then kung sa tingin mo may mga other factors na pwede mo magagamit, kahit hindi siya kasama dun sa 1 to 4, just put it in your argument anyway. So halimbawa, allergic ba siya sa pollen or allergic ba siya sa poultry products, then you happen to be living in the Philippines na haven siya for poultry industry, then you can use that argument, no? So, or other factors na, hey, yung lugar mo sobrang layo sa, may medical condition siya, pero it would take 4 hours for you in case of emergency to drive, then you can also use that argument. So, yung mga other factors na magagamit mo. Then, pag gumawa kayo ng personal statement, hindi kasi siya pwedeng general conversation lang. The rule requires you to establish exceptional hardship in the areas of relocation. Ibig sabihin, yung asawa mo or yung anak mong US citizen magre-relocate with you in the Philippines or kung saan yung home country mo. Then you have to, based on sa sinasabi ko ditong factors, i-argue mo bakit exceptionally hard for them to do that. If you would be able to establish that, then you are already winning 50% of the argument. So, in cases ng may anak na, may asawang US citizen, automatic yun. No question as far as our case is concerned. 50% yun. It will be exceptionally hard. But then, pagdating mo doon sa separation, that will be a challenge. Kasi, example lang, tinawag natin kanina na economic is a ground for the exceptional hardship factors. No? So, sinasabi mo, my husband is earning, let's say, 50,000 a year. but he is not a high school graduate. But kung magre-relocate sila sa Philippines, anong trabaho niya? Anong income niya? So then there will be exceptional hardship, right? But in the case of separation, it means na hindi naman siya magre-resign eh. Nandun pa rin yung income niya. Then, ang i-consider mo na lang is, ay, magpapadala ako ng financial support sa asawa kong uwi sa Philippines. So, then, if the current income, despite providing financial support or spouse support sa Philippines, kaya niya pa rin mabuhay, then there is no economic exceptional hardship. So, again, marami siyang factors to consider. But, if you are doing exception hardship on your own, you really have to put those two scenarios between relocation and separation. So, my next slide basically talks about usual and exceptional hardship. So, when you draft your personal statement and you start saying that it will be hard for me, that it will be hard for, they don't count. No? So the hardship of the applicant doesn't count in the personal statement or exceptional hardship waiver. It has to be the hardship of the qualifying relative. In this case, your US citizen spouse or US citizen child. No? So ano ba yung example ng usual hardship? So yung nababasa namin ng mga personal statement na, hey, namimiss ko yung asawa ko, or hindi na kami magkaroon ng personal time kasi magre-relocate ako sa Philippines or I will be separated from them, that doesn't count. So, ang sinasabi natin is exceptional hardship. So, I actually mentioned a while kanina, no? Kasi may mga cases in the US where hindi siya normal, but there are cases where they are living with the in-laws because yung in-laws nila may sakit. And then yung husband nila happen to be the caregiver of the parents, no? So they drive them to the hospitals or they drive them to attending churches or within the house kasi hindi sila makalakad, kailangan nilang i-attend to sa pupunta ng banyo or whatever, yun, magagamit mo yun as exceptional hardship. So, pero yung mga namimiss mo lang yung anak mo, namimiss mo yung husband mo, that doesn't count. It has to be exceptional hardship. Okay? So, that basically covers the general ground natin for hardship natin, no? Consideration. So, I'm now going back to the questions. This time, we're gonna talk about exceptional hardship questions. So, let's see. Art. Our district has informed us to start, I think, ano ko na yun? What is the time frame for DOS USA to approve a waiver? So it used to be 3 to 6 months, but sa ngayon, 9 months to a year. If you've been following me on Facebook, yung mga cases approved namin, talagang more than a year ang waiting period nun. No? It's becoming longer dahil nga sa dami ng backlog due to the pandemic. So, ang recommendation ko, if you're applying to apply for exceptional hardship, file it the soonest time possible because there's a big possibility that you could run out of status. Paul, can an employer process a green card while serving the 2 year? Yes, kasi nga yung green card, yung buong process na yon could take up to 2 years or 3 years depending on how fast your employer could complete the process. May, I don't know if the question was asked already late. Is conducting training for teachers will help shorten the 2 year? No. But part ng waiver, if you're applying for the no objection statement, is iti-train mo nga yung at least 20 beneficiaries na selected mo or pwede ring ibigay sa iyo ng EVP. No? Kasi sila kasi yung magde-decide kung sino yung appropriate beneficiaries mo. But you could recommend na, hey, I would want to teach at least 20 teachers in my home residence or sa province mo. Try to bring that in the conversation. Malay mo papayag ang EVP, but at the end of the day, the EVP will decide kung sino yung magiging beneficiaries mo. Then, to answer your question, you need to provide training kasi nga hindi ka nang uuwi eh. So 40 hours yung requirement. Uuwi ka talaga ng 1 week just to conduct the training for the intended beneficiaries. What are the requirements of the no objection statement? Again, you can go and check the website of the EVP. Very clear naman ang guidelines ng EVP as to the requirements at saka procedure niya. Okay? Kaloy, can you list the grounds of exceptional hardship for us citizen? If the US citizen child, we go back. What eczema? Okay, so exceptional hardship is exceptionally hard to prepare. Then Yung sa case namin, it really takes about 20 to 40, 50 pages to make that argument. It really depends in a case-to-case basis kasi hindi naman pareho yung case, no? So sa case mo, boss, I really recommend that you set up a consultation with the immigration lawyer kasi hindi siya ganyan kadali. But if I'm gonna read your fact statements here, may mga nakikita akong potential ground mo. No, medical ground for eczema, depending on the gravity kung minor lang ba siya or yung extent ng gravity ng condition na yon. You live 30 to 40 kilometers from Taal Volcano, then you could actually use calamities as part of the argument, which will help you. And then, again, this is based on your facts. Those are examples that you could use in the argument. My family and I received not subject to rule. When is the best time to apply for the H-1B visa? So again, there are two considerations when you apply for the H-1B. Number one, the contractual obligation. So when you sign the J1 visa waiver, you actually had a contract with your J1 sponsor at ikaw na hindi ka mag-change status. Okay? So before you can make that decision, read that contract and then assess for yourself kung kaya mo ba yung risk at liability that may come out of the contract. Let's just assume that, okay, kaya ko namang sagutin yung liability, potential liability mo or potential risk mo dun sa contract na yun. Then to answer your question, when is the best time to apply for the H-1B visa? I would recommend that you apply that within your first 3 years na hindi ka subject to the 212E. The moment kasi na na-extend yung J1 visa mo while you are in the US, chances are magiging subject ka to the 212E. So, to answer the question, and apply for the potential change of status from J1 to H1 during the first 3 years na hindi ka subject to the 212E. Luisa, we are under BIE and our school is willing to sponsor an H1B. When can we apply? Willing din po ang CSA namin to apply the IJA waiver. So, ma'am, kagaya ng sinabi ko kanina, I would encourage your HR to start the conversation with the BIE na local doon sa area nyo, and then reach out to your congressman and senator to help you with their IJA waiver application. Jonas, what if after my 3rd year, 1 year lang ang extension na binigay? Should I wait for my 5th year? I think I answered that question. Yes, you have to wait for your waiver 5th year extension before you apply. If the employer filed an IJA waiver for the employee, is there a need of assistance of an attorney? Ang value kasi ng attorney is to help draft the argument, no? Sa case nung nalaman ko na successfully applied, they have the assistance of a lawyer to at least prepare a stronger argument, no? Kasi hindi siya easy, hindi siya ganun eh. Hindi siya yung tipong mag-submit lang ng documents. There should be an argument. Now, there are schools na sa tingin nila, hindi na nila kailangan ng lawyer kasi nga yung HR nila magaling gumawa ng argument. Then in that case, you didn't need a lawyer. But again, having a lawyer would help kung talagang may case kayo. So, on the IJA waiver though, the biggest challenge is convincing the BIE and getting the support of your congressman and the senator. So, even if you have a lawyer, the lawyer will not reach out to your congressman and senator. It should be your HR reaching out to them. Ang matutulong lang ng lawyer is basically preparing a stronger argument na, hey, bakit ba yung particular person na to or yung teacher na to needs reconsideration for an IJA waiver? Kasi it should be based on performance, it should be based on the contribution of the particular teacher na yon sa school district. So, to answer your question, ma'am, it really depends on the employer. Employer's call talaga yun kung mag-hire sila ng lawyer o hindi. Kasi nga, hindi siya individual application eh. It's the school district who will apply on behalf of the teacher. Marcia, you said we can apply for the waiver after we get the extension. I have informed you na po last June that we have been... Okay, so ma'am, you don't discuss I just want to sabihin ko lang ha, Marcia is not my client yet, right? Nag-consult lang yata siya. So ma'am, we don't discuss that publicly. So send me a message, Marcia. Me and my family got the not subject to 1-2E rule visa for J1 waiver. Kailan po ba yung best time para mag-apply ng H1B? Okay, so I think nasagot ko na to. You have to apply within the first 3 years. So, Marcia, again, I got the message from your staff saying na wait ako sa last year ko dito. Do we have enough time? So, again, kung if you are applying for the exceptional hardship waiver, this is the problem with when you consult a lawyer, and hindi lang yung sa law office namin. No? So, when we actually give, during the consultation phase, when we actually give specific guidance or advice on the consultation, that advice is premised on the specific information we have at the time. So, ano bang ibig sabihin nito in relation to waivers? So, halimbawa, when the question was asked during the consultation that, hey, when is the best time to apply? It depends on nakikita namin na trend. No? So, I'll give you an example. When you apply for the green card application together the work permit, for the last 2 years, you have to wait 6 months to 5 months before the work permit will be issued. But kung babasehan mo the last 2 months, what we've actually been seeing is na-approve na yung work permit in 2 to 3 months. So yun, good development yun. But in the case of the waiver, 2 years ago, the waivers are issued 3 to 6 months. May decision ka na sa waiver eh. Last year, when we look into the trend, 9 months, 1 year, may approval ka na eh. If you actually look into the processing time ngayon, it could actually take 13 months to 18 months depending kung saan ka located. So, anong sagot doon? The decision to apply for a waiver, ang general rule na basihan mo is dapat mag-apply ka nga kung na-approve na yung extension mo. Because if you will apply for a waiver na hindi ka pa na-extend on a J1 visa, then your J1 visa will be denied. Yun yung number 1 consideration mo eh. Ngayon, if you already have the extension, then file the waiver as soon as time possible. No? Kasi nagbabago nga ang trends ng decision when to apply. And that's the reason why I'm actually having this J1 waiver updates. Okay? So, for the clients na nag-consult din sa amin, no? I just want to actually make that clarification. Hindi porket nag-consult ka sa amin, kliyente ka na namin, no? So we only get that relationship if we have a signed contract. So if we don't have a signed contract, it is just a consultation, no? So that's why I'm making these updates for you to be guided na, hey, I think kailangan ko na magpa-reconsult kasi ang dami na nangyayari, no? So, Ma'am Marcia, I would recommend if you could send us a message again to clarify your scenario kasi you cannot hold on to that advice 1 year ago or 9 months ago because things change. And as far as the consultation is concerned, that doesn't create lawyer-client relationship. So, klaruhin ko lang yon on behalf of any other persons who have had a consultation with us. Okay? Next, it's already almost, we've been in live for 1 hour and a half. Magsisimba pa ako, so I might be asking 10 more questions here. Natasha, ongoing petition to grant automatic NOS for J1 teachers with US citizen child. What are the chances of these? There's an ongoing petition to grant. Yeah, I think nakita ko sa kanina when I was actually checking online, there is actually an ongoing signature campaign, right? The change.org to change the na magiging automatic NOS siya. So, ito lang yung masasabi ko. I would recommend though that you continue to reach out to the EVP. In this case, yung Secretary of the Department of Education in the Philippines is si VP Sara Duterte. If you could actually send her a message to support or to make her aware of the concerns nyo, that might help, no? So whether the EVP or the Department of Education respond positively, it is beyond our control, but at least you initiate that conversation with those two government agencies. Now, when I say agencies, the office of the vice president, kasi she happens to be the secretary of the Department of Education. Kasi malay mo, kung ma-air nyo yung concern mo sa kanila, they might be able to look into the issue and they might be able to change the regulations. Kasi if you notice, maraming beses nagbago ang EVP rules eh. So before May 25, 2020, automatic grant naman ang may asawa kang US citizen or green card holder or may anak ka eh. Nagbago lang naman yon nung nagka-pandemic, no? But since the pandemic is already gone now and even the schools in the Philippines started to reopen or start in-person teaching, then it might be okay to reach out to the EVP again or the Office of the Department of Education to change the policy or the regulation ng EVP. Ang recommendation. What is the time frame to approve a waiver? The time frame DOC-USCIS to approve a waiver. So again, ngayon, 9 months, 13 months, 18 months, depending on where you are located. Is it possible for applicant to return to the US in less than 2 years until you complete with the 2-year home residence requirement? Medyo malabong makabalik. But there are people though na merong silang tourist visa and then they were also they were approved for the J1. So when their J1 visa has expired or kasi na-complete na yung program, there are applicants who were able to use their tourist visa to be able to come back to the US on a tourist visa, right? Pero yung natapos mo na yung program mo but you are applying for a tourist visa, again, maraming factors kasi to approve a tourist visa application. So kung ako yung officer at nakikita ko na meron ka pang subject ka pa to the 2-year home residency requirement, then chances are your tourist visa application will be denied. Okay. Edwin. Don, if we hire your office to help me process my visa from J to H1, would you be helping the employer to complete the requirements to submit to Polo? I've heard there's too much paperwork. If the question is, can we help your school district to process the overseas employment certificate through Polo? Yes. You just have to connect us to your employer so we could assist your employer to complete the documentary requirements ng Polo. There are 2 Polo offices, right? So we have Polo in Washington, D.C. and we have Polo in LA, depending kung saan located yung schools niyo. Is it possible that the home residence is after 5 years, or if after 3 years, the contract is extended for another 2 years? Okay, medyo nalito ako dun. Is it possible that the home residency is after 5 years? If after 3 years, the contract is extended for another 2 years? So, if I will just answer this question now, ang home residency requirement ba mag-a-apply after the 5 years or after the 3 years? So, the 2 years home residency requirement applies when the program ends. So, meaning, since your J1 visa is initially issued in 3 years, kung ayaw mo nang i-extend yung 3 years na yon at uuwi ka, then your 2-year home residence requirement starts the moment na after 3 years na yon. Kasi nga, you decided not to extend. Pero kung kunwari, 3 years yung initial J1 visa mo, you decided to extend, so 5 years ka, then yung 2-year home residence requirement mo, magkikick in lang once you go back to the Philippines. So it really depends kung anong decision mo. Do you want to maximize the 5 years and then go home to serve your 2-year home residence requirement, or do you want to comply with the 2-year home residence requirement after the 3 years? Now, I've come across applicants where after the 3 years, they decided hindi na nila mag-extend kasi mas gusto nilang makabalik agad sa US either on an H visa or an immigrant visa. So, depende yon kung anong diskarte mo, no? To answer your question, Edwin. Farida, what does it mean na aggregate 2 years to 212? Good question to, no? So, it means the aggregate. So, example, tapos na yung 3 years mo or 5 years mo, you decided to go home to the Philippines to comply with the 2 years, right? So nagstay ka sa Philippines ng 1 year. But again, for whatever reason, you decided na, you know what, I would want to go to Thailand and teach there for 6 months. And then, nag-Thailand ka, 6 months, bumalik ka ulit. So, nagstay ka sa Philippines ng 6 months. Then after that, pumunta ka ng Indonesia, nagturo ka naman ulit, balik ka naman sa Philippines to comply with the additional 6 months. So, ibig sabihin nun, the aggregate means until ma-comply mo yung 2 years mo, hindi niya kailangang tuloy-tuloy yung 2 years. Pwede mo siyang putulin. Now, as far as the H-1B application or the green card application ng US employer mo down the road, pagpunta mo sa US Embassy interview, bibilangin ng embassy kung ilang araw ka nasa Philippines. So, again, klaruhin ko lang it doesn't mean na pag mag-comply ka ng 2-year home residency requirement mo, na ituloy-tuloy mo yung 2 years. It could be putol-putol. At the end of the day, they will count the number of days na nasa Philippines ka to comply with the 2-year home residency requirement. So, guys, 5 more questions. And again, I thank you for the 300 Facebook Live audience natin na nag-stay with us. So, maraming salamat. I will not be able to answer all questions kasi sa dami. No? Additional 3 questions na lang and we will end the Facebook Live. So, Johan again, if meritorious citizen po, better option po exceptional hardship. I think I answered that question. Daisy, sa experience niyo po, may cases po ba or possible po ba mauuna ma-approve ang green card application without a waiver approval? May case kaming isa, no? That the waiver was approved, the green card was approved na hindi nahingi yung waiver. But then 2 months later, na-realize ng officer na nagkamali siya and then nagpadala sila ng RFE asking for the waiver. And then dahil hindi nga nila ma-provide yun, then the green card will be revoked. At alam din ng client yun. No? So to answer your question, is it possible? Yes. But down the road, you will receive a letter from USIS that the green card was erroneously issued. Faye, yung green card normally 9 months to a year before ng interview. But then again, once you apply kasi the green card, the work and the travel permit, normally ma-issue talaga sa iyo ahead of time the work and the travel permit. So you'll be able to work legally and you will be able to travel in outside the US. So parang green card holder ka na rin nun. Yung kasabay kasi na tanong nito, can we expedite the green card interview? No. Kasi yun yung purpose bakit ini-issue nila in advance yung work travel permit mo. So 3 more questions. J1, nag-file ng waiver pero yung tatay po ng mga bata citizen at nag-file ng petition right after po mag-file ng waiver. Can we stay in the US? Hahanapan pa rin yung mga anak mo ng waiver if they are subject to the 212E. What if the J1 teacher herself has a serious medical issue? Can she apply for NOS? Yes. Humanitarian grounds yun in that case. What is the time frame? I think pag na-deny sa exceptional hardship po attorney, pwede po bang mag-appeal or if may new grounds like having a newborn? So, una, when you get denied of the exceptional hardship, there is what we call filing a motion to reconsider or filing a motion to reconsider or to reopen, no? So it really depends on ano bang reason bakit na-deny yung application mo. So in the case of exceptional hardship, depending kung ano yung reason ng denial, you could file a motion to reopen if the question is more on submitting documentary evidence or additional information. But if ang ground mo is nagkamali yung decision ng officer, then the proper remedy will be filing a motion to reconsider. Or pwede rin combination of both. Then in that case, you will file a motion to reconsider and a motion to reopen. If you get denied on those motions, then you could still appeal your case. Guys, last 2 questions na lang talaga. Tin, you can get the requirements at the EVP website. I am 60 years old. Can I apply for a waiver? You could basically apply for a waiver through the no objection statement, ma'am. Ice, Good morning. What if the J1 visa herself was, again, I answered that question. Denzel, what if po mag-transfer ako na school next year, then willing po sila mag-sponsor ng H1B? Pwede po ba? So una, your ability to transfer school, you need approval from your J1 sponsor. If willing mag-sponsor ng H1B, then it depends if you are subject to the 212E. If you are subject to, then you need a waiver for them to be able to file your H1B. Pag hindi naman, then yes, you can apply. They can apply for the waiver. Okay, one last question. Um, Halimbawa, yung ailing family member from the Philippines and you want to get them for medical treatment, pwede ba yun? Uh, in this particular case, this doesn't qualify for the waiver. But if the question is, you want to bring your ailing member, family member to the US for treatment, then mag-apply sila ng medical emergency visa. It's in the same nature of a tourist visa. But ang magiging ground mo is medical tourism. But it's a little bit challenging though kasi nga when you apply that at the embassy level, hahanapan ka ng proof of ability to pay kasi alam natin na mahal ang treatment in the US, no? And then you also need to prove that you already have prior consultation with the doctor or the hospital where you would need the treatment from. But then again, guys, thank you very much for attending the live today. I need to and the Facebook conversation. I will continue to share my knowledge and my expertise as far as the J1 visa waiver is concerned. Alam ko that for the teachers, this is what's more important issue to you. So trust that I will continue to give you updates, whether it's on the NOS side or the exceptional hardship updates from the Department of State. So again, maraming salamat sa inyong lahat. Good night and good morning here in the United States. Bye-bye.